welcome to Anatomy of a Trademark / Merchandising License Agreement. I'm Adrian Syhan, Chair of the Beverly Hills Bar Association's IP Law Section, and I'm delighted to introduce today's speakers, Greg Battersby and Danny Simon. Gregory J. Battersby is the managing partner of the Battersby Law Group, LLC's intellectual property law firm in Westport, Connecticut. He has over 50 years' experience in patents, trademarks, and licensing law. Before founding the Battersby Law Group, he had been a founding partner in Grimes and Battersby. He had previously been associated with two major New York City IP law firms and was senior counsel at Gulf and Western Industries, now Viacom, and the then owner of Paramount Pictures. Danny Simon is a 40-plus year licensing industry veteran with expertise in all phases of the merchandising and licensing process. Having built the licensing divisions for Lorimar Productions, 20th Century Fox, and Coralco Pictures, he opened his licensing agency in 1992 in Los Angeles, called the Licensing Group Limited. Danny has pioneered entertainment licensing, focusing on material geared to the teen plus market. Beginning with the television program Dallas, he was among the first to license adult, primetime television entertainment, and with Dynasty, he was the first to apply branding techniques to television shows. So with that, we're very fortunate to have these two prominent speakers with us, and let's get started.
Welcome. Welcome all. We're going to be going through this is a pretty basic trademark / merchandising license agreement. I would say it's plain vanilla. It's not the studio type agreements, which can run anywhere from 3 or 4 times the length of this agreement, but it hits all the high points. And what we're going to try to do, I'm going to be giving it a little overview as we go through a number of the provisions in the agreement. And then Danny will address it from the licensor's perspective. I'll address it from the licensee's perspective. And we'll see if we can come up with some sort of a compromise, because there's always a push and pull between licensors and licensees. Well, as I said, this is going to be a very basic agreement, mostly directed to merchandising, and it starts on page 1 with an identification of the date of the agreement, which is the effective date, and the parties to the agreement. The licensor is listed, in this case, as Big Time Baseball. The licensee is listed as MLB LLC, a Grand Cayman limited liability company with offices in Grand Cayman. Danny, you have any thoughts on that?
Yeah, just always be careful as to where the company is located. I see Grand Cayman Island, I get just a tad nervous.
And the reason for that is pretty simple, because you wind up, the licensee is going to have obligations under the agreement. If the licensee is a major licensee with financial wherewithal, you've got no problems. If it's a shell company set up offshore, you're going to have trouble trying to enforce the obligations against them. So be careful when you identify who the parties are. The next thing we walk to is the whereas clauses, and we use the whereas clauses here for definitional purposes. We'll identify the property, which is being licensed. We'll identify the trademark, if there's a trademark, the licensed products, the territory, and the channels of distribution. There's a difference between territory and channels of distribution. The territory is typically the geographical area. The channels of distribution would be the stores or the venues where the product is sold. For example, if it can be sold online, if it can be sold in major retailers, mass market, specialty stores, or what have you, that would be channels of distribution. What we typically do with this agreement is we use the Schedule A, which is the back of the agreement, to do all the definitional purposes. The logic is simple, frankly, because we structure an agreement this way, and we turn it over to the business people to negotiate. They literally have an outline in the schedule to negotiate, and then come back to us as the lawyers, which we can kind of fill in the pieces in drafting the agreement. The next step we want to go to is the license grant. Most license grants in merchandising are non-exclusive, and the reason for that is fairly simple. Danny and I first started in this in the 70s and 80s. The vast majority of the agreement were exclusive. Then the laws of bankruptcy stepped in, and licensors got tired of finding a licensee who was underperforming with an exclusive agreement and couldn't enforce it against it. So as a result, the pendulum swung, and it got back to more of a non-exclusive agreement. You'll see a provision at the end of the paragraph 1A. I call it backdoor exclusivity. But it's the licensor, if the licensee is not in breach of any provision of the agreement, the licensor agrees not to grant a license to any third party that may be in conflict during the term with the licensee during the term. Significance of that is that if the licensee is performing, the licensor is not going to find another licensor. Danny, what's your thoughts on that?
Well, that works for most categories. There are a number of categories out there where non-exclusive means not exclusive because no one company could handle the volume to satisfy the market. And best example is t-shirt product for there's no company out there that can really provide the whole marketplace. As the number one selling item in the country, t-shirts get sold at a variety of places at a wide range of price points. So we generally are going to look for multiple licensees in a category like that. So if you're talking about a major toy product where there's heavy expense in development of molds and there's a smaller volume potential, we generally can agree to that. We wouldn't agree to it on a product that has a better potential to allow multiple manufacturers in.
The category is an interesting category because there are many types of toys. And when you're granting a license, particularly on an exclusive basis, but even on a non-exclusive basis, you want to identify the particular product with specificity. Granting a license for toys is difficult because it covers the entire range of all toys, as opposed to action figures made of PVC, not to exceed 2 inches in length or in height. That would be a more appropriate grant for a toy product. One of the things, if you're going to have to paragraph 1C, there's no sub-licensing. Sub-licensing is typically not mandated or not, it's allowed, but it's not generally granted in a merchandising license agreement. There's a difference between sub-licensing means that the licensee can step in and assign his rights over to a sub-licensee who will step into the shoes of the licensee and perform. They're a distributor or a manufacturer typically are not sub-licensees. They're distributors and manufacturers. Lastly, here is the term of the agreement. And again, this is going to tie back to the schedule in Schedule A at the back end of the agreement. But there's all sorts of various theories on the term of an agreement. Remember, in an entertainment property, which may be a motion picture, not necessarily a television show, but a motion picture, the terms tend to be short. If it's a television show, the terms are going to be much longer. If it's a classic property like a Winnie the Pooh or a Donald Duck or a Mickey Mouse, they'll be much longer. If there's depending upon the particular product, food products take a long time to be developed and tested and into the marketplace. Those license agreements tend to be longer. Electronic agreements similarly tend to be longer for the simple fact that the time it takes to develop the product is much longer than it does to make a t-shirt. Danny, what's your thoughts?
A classic example of the disparity in timing of the amount of time you would grant in a license. The best example is to talk about an A-title video game where you're talking about multiple millions of dollars of investment costs and anywhere between 1 to 3 years to actually get the product out to retail. A company comes in and they're going to want at minimum probably a 10-year license. The other factor can be if you're licensing something where there's a brand opportunity, where the manufacturer is trying to build a brand name out of the license in his product category. Let's say a perfume, for example. They're going to want either a longer term license or definite, easy way to continue to renew the agreement on an ongoing basis because they're trying to build a position in the marketplace for a long-term play.
Things I try to do when I draft a license agreement is to build in landmines, for the want of a better term. I want to make sure that if the licensee is performing, they should be able to continue the license. If they're not performing, as a licensor, I'm going to want the ability to get out of the license. And a long-term license agreement can be problematic because if the licensee isn't performing under a 10-year deal, it's going to be difficult to terminate them. Now, you can do this a number of different ways. You can have a 2-year deal with options to renew for a period for one option, 2 options, multiple options, provided they have certain performance milestones. If they meet those milestones, the licensee has a right to renew the agreement under the same terms as the agreement provides. If
A
they don't
miles
meet milestones, then they can
a
be.
milestone that's often used is to utilize a guarantee or a multiple number amount of the guarantee as a revenue base to continue to renew the agreement. For example, 150% of the guarantee paid in royalties over the term is a pretty usual benchmark for a number of licenses. Also, too, the amount of money you spend in advertising and or the number of retail outlets you've penetrated, or the geographic territory that you have under license if you have penetrated it totally. Those things can all be used as benchmarks.
Yeah, the common thread is obviously performance. If the licensee is performing, they should be able to hold on to the agreement. If they're not performing, the licensor should be able to terminate them and move on. Next slide is compensation. In merchandising in particular, the vast number of majority of the compensation forms are royalties, a percentage of the sales of licensed products by the licensee. Royalty rates, it's a whole study. We actually have a book published by Walters Kluver, which is licensing royalty rates, which take 8 different categories of licensed properties against 1,500 or so licensed products, and identify and report on the average royalty rates as well as the median royalty rates. But that's the heart and soul on the financial portions of an agreement. That goes hand in glove with a guaranteed minimum royalty, which is paragraph E. Danny, what's your position on guaranteed
Well,
royalties?
on royalties, what we should note is that there is no fixed royalty in any product category for any property at all. These are numbers that are arrived to by mutual agreement. However, there are what we'll call standard rates within various product categories as to what the usual amount of royalty that's charged by the licensor. That doesn't mean that's what the parties in this contract will agree to, but that is an average or a standard range. What you also have to discuss is what is the royalty based on? Generally, it's the wholesale selling price of the product because that's the amount of money that the manufacturer or the licensee controls. However, in the direct market, where the licensee is acting as both manufacturer and retailer, we often want to see the royalty based on the retail sales price of the product. So our position in royalty on a direct sale is considerably better. Is that fair? Well, yes, it's fair because the remuneration to the manufacturer is considerably greater. So we want to share in that. Now, a lot of licensees will want some discount between the wholesale rate, say it's 10% of wholesale sales, they may be asking for 5 to 8% on direct sales. Whether you grant it or not is a negotiation.
There's another type of royalty called an FOB royalty. What the trend, particularly in a lot of the consumer products, is that a licensee will actually manufacture a product abroad, let's say in China, for example, and they will sell the product to the retailer on an FOB basis in China. The retailer then is responsible for bringing the product back from the offshore manufacturing facility and selling it in the States. Uh, the FOB prices are typically lower than the domestic selling price. For example, if the net sales price for domestically is $10, the FOB price may be $7. So what licensors want to do, they're going to want to adjust the royalty rate because they want to make sure the ultimate the earned royalty, the amount of money they make, is the same because it's going to be a lower selling price. So be
What
careful of FOB rates because you're seeing it more and more as product gets manufactured offshore.
Well, what I think is going to happen, Greg, is I think that with this new issue of tariffs, that FOE pricing is going to get more popular because it's going to allow the manufacturer to buy the product cheaper as a tariff rate, I think,
That's
unless he
true.
gets taxed with the added cost of shipping and other other onboarding costs.
Danny mentioned the wholesale selling price. If we look at paragraph F on the next slide, that's the definition of net sales. Now, that provision is negotiated every day in every license agreement. And I will tell you as a practical matter, that same agreement will be read by the CFO of the licensee in a different manner than the CFO of the licensor, because that's the corpus, for the want of a better term, of what the royalty is going to be based on. The licensee is going to want to be able to throw as much expenses as he can against sales to reduce the royalty rate. The licensor is going to want to limit the amount of deductions or allowances which they can give. One of the common solutions is that it's gross sales less discounts, allowances, and returns in a broad sense. What constitutes a discount and allowance are always a subject to negotiation, and is a return for defective products or return across the board. Most licensors and licensees will agree upon a cap for that. It eliminates a lot of the negotiations back and forth, and it aids in the auditing down the road. Caps will run anywhere from 5% to 10%. So that surprisingly, magically, the licensee always manages to have enough deductions to reach just below the cap or right at the cap. It's always surprised me when how that works. But
Well, what
yeah,
I
go
want
ahead.
to add that one thing that we will never agree to is to allow for your advertising costs to be a deduction because that's just simply a way to allow the licensee to uh, utilize what would be your royalties to pay for marketing of their product. So one thing we do not allow is advertising costs.
Well, Danny raised the issue too about tariffs. I haven't seen tariffs identified as an allowable deduction, but you're going to see it more and more, I think.
Oh, yes.
So be careful of that and think about that. And there's also tariffs the other way. Tariffs from if the stuff's going out of the United States and into abroad, into China or whoever. So be careful of that and think, consider how you want to handle it in the combination of definition and net sales.
What you don't want to do on tariffs is if the licensee is not going to raise prices substantially, but will eat some of the tariff costs, you don't want to be in a position where you're giving him the full allowance of the tariff if he's not actually losing that money.
The provision J is acceleration. That happens to be one of my favorite provisions if I'm a licensor. What it means is that if a licensor terminates a licensee and there's a balance of a minimum royalty required, those balances are accelerated. They're due and payable upon termination or expiration of the agreement. It avoids a licensor being in a situation where he's got to collect monies from a terminated licensee this year, next year, and the year after. So important provision in the agreement.
Yeah, great. Uh, Also, currency is another issue, whether or not it's paid in dollars. If you're the U.S. company doing business with a foreign licensee, do you want to see monies coming in dollars or their local currency? Generally, we don't like to play currency games in terms of betting on the values, so we'll peg it to the dollar rather than to the local currency.
Audit provisions. Danny, what's your position on auditing a licensee?
Um, Mixed. Audits are expensive and time consuming and a royal pain for everybody involved. Uh, if you have a good licensee and you've done business with them and you don't suspect there's a incorrect count, then we generally believe the royalties as they're being submitted. If we have any question or if we feel that we see more market or more product in the market than we think we're being accounted for, we'll definitely audit. but it's our right and one which we always want to have whether we use it or not.
As a licensor, I kind of prefer an audit. What I also recommend to licensor clients is audit early. And the reason I like auditing early is because if there's a problem on the licensee, it could be an innocent misunderstanding of what net sales are, or misunderstanding as to how we should account. It's better you find that early than later, because if you find it early, they can make the change and it's not a lot of money. If they find it later, 2 or 3 years worth of sales, the number could be substantial, and then it becomes a fight. So
Well, it also impacts how long the audit will take. If you're auditing somebody in the first year versus a third year, there's simply going to be a much faster answer as to whether or not there's any improprieties with regard to the amount being paid.
for specialty auditors, I mean, we work with a couple of firms over the years which probably do 30 or 40 audits, licensing audits every year, or maybe every quarter, actually. You're probably, if you're looking for auditors, you're probably better off finding somebody who has the experience in auditing. They know what they look for. Most of the audits now are not done in person. Most of them are done electronically, and they work fairly well. There are provisions I'm sorry, go on, Danny.
No, there are some auditors too that will work on a contingency basis.
If you look at paragraph B, that's the penalties for, usually the licensor is responsible for the cost of the audit unless they find a problem. And depending upon what the problem is, then that obligation may pass to the licensee. In this case, it's usually a percentage of what the underpayment is. Typically, it's 3 to 5%. If the underpayment is more than that, then the licensee is responsible for the cost. We have a separate provision in here. If it's gross, if it's much greater, 25%, or pick a higher number, then that should give the licensor the right to terminate the agreement in the event, because they're not dealing with a misunderstanding. They're not dealing with a misstatement. They're potentially dealing with fraud on the part of the licensee. Look for record retentions, because that's important, because as a practical matter, if the licensee isn't maintaining the records, running an audit can be meaningless. You're not going to be able to find the records. There's a lot of provisions in some of the more sophisticated agreements which provide specifically that if the books and records aren't kept properly, aren't maintained, then there'll be a penalty. And the penalty could be 100% royalty on everything sold. They can be draconian. I've seen a couple of them, which are truly draconian. Warranties, reps, and warranties. Danny, as a licensor, what are you looking for?
On warranties and reps, I'm looking to make sure that I'm protected from anything the licensee may do that could cause damage or could cause litigation of any sort. We also want to make sure that the licensee is performing in a positive business practices, and that essentially we're protected. If we could throw in there too the insurance indemnification, because it kind of flows with that, where we're going to require product liability insurance of a minimal amount, which tends to be minimal 2 million per occurrence, and it goes higher depending on what the product is. We want to make sure that we're protected from any problem with the product as well as with the operation of the licensee.
As a licensee, I'm looking for a rep and warranty about non-infringement. You'll see paragraph B. I want to make sure that when I take a license, I'm paying the licensor a royalty for the right to use their property, and I'm marketing products. I'm not going to get sued by anybody else. Surprisingly, over the last few years, I've been seeing more and more licensors abrogate the responsibilities for this. To me, the grand bargain is a simple one. The licensor has a property, should be protecting it. The licensee agrees to take a license under it and pay the licensor a royalty, but they want protection. So I'm seeing more and more licensees backing out of this rep and warranty on non-infringement. The
We're
argument they'll come back to is that I'm indemnifying you in the event that you get sued by a third party, and that's wonderful. But I'm still forced as a licensee under that agreement. I can't terminate the agreement even though I'm in the middle of a lawsuit. So a licensee should be looking for that rep and warranty on non-infringement.
I'm generally happier with reps and warranties to the licensee about my property than I am being forced into a situation where I have to cover with trademark filings every product category in every country imaginable. So sometimes we will rather risk not having to go to the expense of filing in a particular country for a very specific item if we don't think it's going to cause problems, and then give the rep and warranties to the licensee instead.
Paragraph E is an important provision because remember, we're drafting license agreements with landmines in there. They have to be performance oriented, and the product introduction and initial shipment dates are some of those landmines. The licensee has to have a product, the toy product, for example, has to have that product introduced at Toy Fair of a date certain, has to be shipping product on a date certain. And if they don't meet those dates, the licensor should have the obligation or have the right, not the obligation, but the right to terminate in that event.
The opposite is also true, that you'll have situations, and particularly with things like movies, where you don't want product out before a certain date. So there's also the opposite where we want to withhold the licensee from shipping product until a certain date.
Notices, quality controls, and samples. A trademark license, the heart of a trademark license from a trademark point of view are the quality control provisions. A licensor who does not enforce the quality control rights on a licensee runs the risk of being accused of naked licensing, which can result in a loss of trademark rights. That's the biggest liability a potential licensor has. So you'll take a look at these agreements, which this is a relatively modest provision with regards to quality control. The studio agreements are 7, 8, 9, 10 pages long on the quality control provisions. They want to be able to make sure that the licensee is submitting for product for review and approval at various steps of the operation, as well as after they've started manufacturing product, they have a periodic review and approval thereafter.
One
And
thing about a property licensed product for review, that's something that we take extremely seriously, and certainly one of the things we give the most attention to as quickly as we're served with the product to review. But it's also a problem in that most products will generally go through a multiple cycle of review, meaning that a lot of times product the first time around isn't approved. The manufacturer is required to give comments as to what the problems are. I can't just say I don't like it, fix it. I've got to tell you what I don't like about it and the ways in which you need to fix it. That's my obligation. But in the meantime, it's your obligation as the licensee to continue to submit it until it satisfies our demands. Now, we don't want to be unreasonable, but in the case of a character, we want it to resemble exactly the character. And if you choose not to use an image that I provided for you, but create your own, then you've got to take great care in duplicating that image. And I'm going to make you work on it until it is correct. One of the things that people complain about the most is the time it takes for licensors to respond. And that is a problem in our industry. My brother and sometime are not great at taking seriously the fact that manufacturers are on a schedule. And my sitting on an approval for no reason can cause a lot of problem with the manufacturer meeting those deadlines. So great attention has to be paid here by both parties. When it works well. When it doesn't work, it causes big problems.
One of the twists always is because Murphy's Law applies is a product will be a sample will be submitted which never gets received by the licensor. And as a result, the licensee doesn't get approval going forward. The licensee is going to want a non-response by a licensor as approval. Licensees will never grant that. It'll always be disapproval because that's the one product they don't want to make sure is in the marketplace, which hasn't met either the quality control provisions or complied with the marking provisions. So be careful about that. Now, Danny made a comment about wanting to be reasonable. I will tell you, when I represent licensees, I ask all the time about putting a reasonableness provision in there that the refusal cannot be unreasonably withheld or delayed. Every time I ask for it, I'm denied that. So
Yes,
most
because
licensors
what's reasonable to you may not be reasonable to me, and it's my property, so I'm the arbiter here.
That's what they tell me, Danny. That's what they tell me.
Of
So it's
course.
usually at the sole discretion of the licensor. So if you want to try to negotiate reasonableness, good luck. Unless you've
What's
got
what's made this process much easier is that 99, if not almost 100% of all approvals today are done electronically. When we started out in licensing, you actually had to mail that physical sample again and again and again, and it gets expensive and time consuming. So today, approvals are much easier, and most licensors of any substance are using electronic submission platforms, uh, electronic apps that are dedicated to the submission of product for approval, which has made the whole process much easier.
next provision, ownership of rights. Pretty simple. The property owner, the licensor, owns the property rights in the property. What the licensor is also going to want to do when he can is own
The mic is muted.
any products, any IP or any works which are developed jointly between the licensee and the licensor during the term of the agreement. Danny, how far do you want to go on that?
All the way.
All the way, of course. Because,
Wow, what'd you have in mind?
well, the provision, if you take a look at 8C, it's a work for hire provision, and basically the agreement provides that anything which is developed, potentially copyrightable, but anything developed by the licensee during the term of the agreement is deemed a work for hire as to be owned by the licensor.
If it's a testy issue, because technically I can claim whatever you do as my property, meaning you create a design, although it's one you created, it's of my property and I therefore own it. I think licensors have to give due consideration to how they apply that, because is it fair to take and create product in the marketplace that replicates a licensee's design of your property that could create competition to his product, which is possible. Particularly if you have, again, T-shirts and you have licensees giving you great designs, would I turn around and hand that design to another T-shirt company? Technically, I can. The question is, should I? And I don't think you should.
As representing a licensee, what I will typically try to do is to carve out anything which was owned by the licensee prior to the effective date of the agreement. That remains the property of the licensee. It won't get picked up as a work for hire or as ownership of design or rights by the licensor.
A lot of times you'll find that video game engines fall in that category, where we'll do a license for a video game where in fact the manufacturer is taking an existing game engine and reskinning it with my property, maybe making some changes to the play action, but essentially using the same engine. I don't claim any rights to that engine, but he can't claim any rights to the image of my characters.
And it'll also relate to product configurations too, because frequently what a toy company will be manufacturing a particular product and all of a sudden slap a licensed property on it. But it's the configuration of the structure of that property was owned by the toy company before the agreement. They should be able to retain rights to it.
Um,
Use
this,
use inures to the benefit of the licensor, which is paragraph G. It's kind of a technical term because when trademark rights are based on use. A licensor who goes out to file a trademark application and prosecute the application based on a licensee's use will have to demonstrate that the use was inuring to its benefit. And the trademark office frequently will require or at least ask to look at the provision of the agreement, which states that any use by the licensee shall inure to the benefit of the licensor. That covers the use uh, requirement.
um, I'm going to go back to your last question about using licensees material. We've entered into a number of in some agreements where the intent is upfront is to reuse that material. For example, we just did a big art book on the property Ultraman, and it's original art by probably 150 plus artists, all under work for hire. And going into it, the deal was made that we own that artwork and we will and do intend to use it for other product. Uh, the licensee knows that going in, so we've acknowledged upfront our intents, which I think is the way you should operate when you want to reuse material that you haven't actually created of your property.
Makes sense. Termination, which is on paragraph 9. I've over the years when I've done this program, I've asked people when we go into it to pick before we start the program as to what they believe the most important provision in a license agreement is. And generally, it's royalties, it's guarantees, it's quality control, what have you. To me, the most important provision in a agreement, if I'm representing a licensor, is termination. I want an ability to terminate a non-performing licensee. And there are a number of things which are absolute requirements of the licensee. And if they fail to meet those requirements, I have the right to terminate immediately. There's another more amorphous issues, there may be a cure provision. But if you can see in paragraph 9A, it's a list of the ones
You're
where
not, I think you got to change the screen, Greg.
I thought I was there. You know,
There you go.
9A, immediately terminate the agreement. Failure to meet the product introduction date, failure to meet the initial shipment date, failure to pay royalties on time more than once, failure to maintain product liability insurance, on and on and on. Those rights are really non-curable. They should be at the basis of an immediate right to terminate, and you'll see them here. The next step, Danny, what's your thoughts?
Well, I think the case of curing breaches, if it's a payment issue, if it becomes chronic, that's another issue. I don't consider one-time payment late being chronic, and I think licensees should be given the right to fix the breach. And same is true for those of lesser import. Uh, because you have the right to terminate doesn't mean you should. And sometimes a mistake is just that, a mistake. And I think these have got to be used judiciously and not for an attempt to grab back rights that you've got another licensee who'll take it on if you can get rid of this one.
Frequently, my experience has been that it's a bad if you're in a bad relationship with a licensee, you're not happy what they're doing, and now you're looking to terminate, but you need a basis to terminate if you want to terminate them. So that's where these provisions become important. In and of itself, failure to make a payment, paying royalties on time once or twice should be should not be a big deal. But if it's done continuously, then it becomes more of a problem, particularly if the licensee is not selling which in an amount you want them to sell into. So that's why these provisions are here. But you'll see the next is an immediate right to terminate a portion or the right to terminate by the licensee. Rarely do you see a licensee having a right to terminate, but they should as a practical matter because it is a bilateral agreement. But on the paragraph B is the right to terminate, or paragraph C, right to terminate on notice. The notice provision is typically a 30-day notice provision for cure. If it's a financial issue, it should be less than that. if it should be 10 days, 10, maybe 10 business days. But you want to accelerate that cure period in the event of a financial issue. Danny?
It's funny. I was just thinking about what we as a licensor need to do to satisfy an agreement. And you mentioned the licensee looking to maybe terminate an agreement for failure. What I've never been asked for when I've been asked, I ask for a marketing date. Nobody ever has asked me, well, what date will we get the materials from you to begin development? Which is a reasonable question, but one that generally never gets asked. So when you're committing to making these dates, as a matter, of course, for the licensee, and now I'm going to play your side, Greg, is you really should be asking for certain benchmarks for the licensee to perform. Although I'm not going to give you a reasonableness in approvals, I will give you a term of time by which I need to reply. The problem is if I don't reply within that time, I'm going to deem it not approved. So you don't win much on that basis. But if you're acting, have to act within a term of a specific time frame, then you should build into that the fact that the licensor has to perform certain functions that allow you to get to that date or meet that date.
Makes sense. Do you do that, Danny, in your agreements?
No, no, I don't give them anything more they don't ask for.
Okay, that makes sense. That makes sense. Okay, sell-off period, which is 10B. Upon termination or expiration of the agreement, the licensee typically has the right to sell products for a period of time, and that period of time is always negotiable. What do you normally give for a sell-off, Danny?
I usually use 180 days. Um, if you can't get rid of the merchandise in that period of time, then it's not going to get moved probably. And we have to end it, whether it gets junked or I demand it and you have to give it to me, or I give you a fee, a price rather for it on a heavily discounted price. Uh, However, it's agreed to, it should be relieved by no longer than 180 days,
I put
unless there's some.
provisions. I put provisions in there as opposed to returning it to the licensor. I'll donate it to charity, charity mutually acceptable to both parties. But there are a number of organizations, mostly out of New York, I'm not sure worldwide, which will take it for underprivileged children, particularly the children's products, and it's a wonderful thing to do.
Better than burying it in the desert.
Or rolling over with a steamroller.
Can I just regress for a moment? What we didn't talk about when we talked about going way back to the advances guarantees, the actual dollar values of the license. Uh, the biggest question I always get is what does the license cost? Which is a question that I know if I'm asked that question, somebody is a neophyte in licensing, because there is no fixed cost to a license. It could be free if I wanted it to be, if I'm controlling the rights. The question is, how do you get to a fair agreement as to what an advance or a guarantee should be? What I always think is the most important element of this contract is the royalty provision. The amount of money I'm going to get paid per product sold. That's how I make a living. That's how licensors thrive. So for me, everything else is second to what am I going to see as the value back on the sale of that item. And as I said, technically, there's no fixed royalty rates out there. There are significant amount of averages being paid for various categories. In the toy business, it used to be 8%, it went to 9%, 10%, now it's 12 to 14%. Foods, which is a commodity that has a very, very small profit margin to it, because it's a volume item. You're going to see royalties anywhere from 0.5% to maybe 3%. Occasionally, you might get 5 on something that can demand a higher price point. But once we set a royalty, now all I need to do is to get an idea as to what amount you think you could sell during the term of the license. And that's going to kind of create at least some framework around making a deal. Now, I know you're going to lie to me when you give me uh, uh, a
Projection.
amount that you think you're going to manufacture. I know that you're going to under report that number to me. I know that going in. So I've already factored that into the conversation. You say you're going to sell 10, I know you're going to sell 12 to 15, possibly 20. So you look at those projections, and that's where I've often find the way to make a fairest deal. I'm going to give you some leeway in it, and you know that I'm going to try to get as high as I can. You're trying to get as low as you can. But reality, the amount of goods that get sold over the period of the license is what the value of the license is. The problem is neither one of us knows what that number is at the beginning of the deal. So estimates of sales volume, I think, are one of the fairest ways to get there, but just know the games that are being played by both sides.
I think it's a two-edged sword for a licensee though to underestimate what their sales are going to be. Because if they underestimate it enough, they may lose the license.
Yeah,
Licensor may say,
exactly.
I'm not
It
going
may
to
lose
license.
the interest of the licensor.
Now, typically what I'll do is I'll rely on those numbers and let's say it's a 10, we negotiate a 10% royalty and the licensee says that I'm going to sell $1 million. So that's a 10% royalty and my royalty is going to be $100,000. I'll ask him to guarantee half of that and pay half of that as an advance.
Right.
And that's a simple, easy way to do it. But I tend to rely more on what the licensee is telling me than maybe you do, Danny. Um,
Well, I do rely on what they're telling me. I just know that there's going to be some underreporting. And frankly, you'd be crazy to report what you thought you actually could sell, because if you overestimate your sales and your deal is based on those numbers, you may be in a position to have not met your guarantee by the end of the license, which is in a position neither of us want to be in. I don't
yes.
want to have to go after you for recouped guarantees, and you don't want to have to pay me on sales you never made.
I
So,
have a rule of thumb in that situation. I call it an effective royalty rate. I may negotiate a royalty rate of 10%, but because the guarantee is so high and my sales are so low, the effective royalty rate can be 100%. And that just is inequitable for certainly for the licensee, and it's not a good position for the licensor because they're going to have to try to find another licensee, and they have that inventory behind them. Uh,
right. And
next
and
provision. Let's Next provision is insurance.
that's a good provision.
That's a good provision, which is paragraph 14. Typically, this provision typically focuses more on product liability. And there are products which tend to be more prone to a product liability claim than other products. Product liability generally is a US based problem. We see it occasionally internationally, not as much, not nearly as much, but it is a problem in the United States and particularly certain products. Toys have a tendency to have a higher product liability rate, maybe than T-shirts. Though children's clothing is prone to product liability claims, and we negotiated back and forth with regards to what the claims are. Danny mentioned that his standard is about 2 million. I go generally a little higher in the toy category in particular, maybe as much as 5 million.
Oh, sure.
Watch out for.
I've
Watch
done
out
a
for.
lot of knife licensing, and we get a minimum of 5 million.
Yeah,
You do a lighter deal, you got to have plenty of liability insurance. I mean, if it shoots a projectile, Uh, whether you want to license it or not is a question, but products that are hazardous by their very definition require greater protection.
Be careful with product liability insurance because it's like any insurance policy. There's a deductible. If the deductible is so high, it becomes almost ineffective. So we'll require from a licensor, I'm going to actually not only have the limits of liability, but also what the maximum deductible that keep it relatively low. The other thing which I want to do is I want to qualify the carriers they're using. In this case, it's a best rating of A minus or better. We had situations way back when with toxic shock syndrome where carriers were going bankrupt, and that doesn't help you in a product liability case. So, last but not least, the licensor is going to want to be named as an additional insured under the licensee's policy. Generally, there's no cost for that. So, as a practical matter, every licensor should not be reluctant to grant that.
And if you have an agent, we also as agents have asked for the same protection, along with the licensor.
There's force majeure, which is becoming an issue. It became an issue during COVID. I make sure that the provision, excuse me, I make sure a provision about pandemics is in there. I try to also put a provision in there with regards to supply chain disruptions and things like that. There's jurisdiction dispute. A licensor is always going to keep the law of his home state there as a practical matter for governing law, because they don't want a dozen licenses out there with the jurisdiction of a dozen different states governing it. It should be the home state or a mutual or a single state by the licensor. New York has a provision which permits you to use New York law even though the parties aren't in New York. So consider that. Disputes is another provision which is always negotiated. Litigation, arbitration. I'm an advocate of mediation as a requirement before you even get into arbitration or litigation. Danny, what's your
Greg, change the screen.
I'm on it. I thought I'm on it. Paragraph 16. Is it there?
Yep, it's there.
Okay. I'd like to add a provision that the parties will agree to a mediation before they initiate disputes. It's just, hopefully it'll save some time, it'll save some money, and get the parties talking to each other. My experience, frankly, has been a lot of the clients they don't want to talk to their adversaries, so they want their lawyers to talk to the adversaries. That's probably the most inefficient way of resolving a dispute. So get them in a mediation room with a mediator who knows what they're doing and try to resolve it. Next provision is assignability and transfer, and this leads to a provision called the transfer clause, which is becoming more and more prominent in most license agreements. And basically, a licensee who wants to sell their business, transfer the license along with the business, a licensor is going to want to charge a transfer fee in order to do that. Danny, what's your position on transfer fees?
Well, we talk about this, whether this is a fair question from the licensor or not. If I have a license that's significant, like a Disney license, has that propelled my company into doing better and therefore more financially viable for purchase by a larger company? Disney will make the case, yes, it does, and therefore we want a taste of that transfer, that sale, because we've helped you become more profitable as a corporation, not just within the product category that we've licensed you. So one can make the argument that there's some justification for it, but it's what I think of as a greed clause. It's some people will try to get what they can. It's hard to prove it. It's hard to disprove it. And I don't know how you go to court and make this work if you had to, but it's getting to be a problem as people value licensing more.
What I'm seeing more, I see more frequently than I'd like, is an amorphous number as opposed to a fixed number to be determined by the licensor. The problem I've got with that is a licensee, if they are in play and they're going to sell the company or transfer the business, if they know what the number is going to be for a transfer fee, they can build it into the selling price of the business. If they don't know what the number is going to be, and it's amorphous, it becomes more difficult to build it into the selling price of the business. So I always insist upon some sort of a number. We can negotiate the number, but a stated number. Now we're going to
And
jump.
as we talked about before, Greg, if the where it depends too what the status of the license is.
Yeah.
Is the agreement, reasonably new with a number of years to run, or is the license about to terminate within 6 months? So the question is, the time that's left on the license is also a factor to be considered.
And how much has been paid already? If the guarantees have already been met at that point, the idea of transferring it should be a nominal fee, not a major fee. Schedule A, that's what we talked about as an outline for the business executives to negotiate. We identify the property, the trademarks, the licensed products, and again, the licensed products with specificity, not just toys or not just apparel, but it's men and women's cotton t-shirts, sleeved, sizes small to extra large, as detailed as you can. Similarly, the territory and the channels of distribution and the terms. We didn't talk, I guess we talked a little bit about the guarantees before and the royalties. And you see under the royalty rates here, you're seeing a domestic rate, an FOB rate, and a rate on direct sales. Danny, I think, tends to be more aggressive on the direct sales rate than I am. I tend to believe that the direct sales royalty should be lower because the selling price is going to be higher.
But wait a minute. You're making sometimes double the income on a direct sale because you're not selling it for wholesale price, you're selling it for a full retail price. So you're making a significantly bigger margin. Why aren't I entitled to some of that?
Classic licensor. I love them.
Yeah, well,
We get
you want my mouse, you got to pay for my mouse.
okay. This is the code of Lima's Licensing International's Code of Business Practices. One of the conditions which you want a licensee to follow, and it's basically fair labor. There's a number of groups out there which have it. Fair Labor Association has one. Most of the major retailers have ones, but you want to hold the licensee's feet to the fire with regards to what I refer to as the Kathy Lee Gifford clause, because that can be a black eye down the road if the licensee all of a sudden has been manufacturing product wherever using child labor or prison labor or unsanitary conditions, because that's going to be a reflection on the licensor. So this should be built into the agreement as an exhibit, and it should be a termination right. I'm going to go through a couple of Battersby's laws on licensing. Danny's got a couple of Simon Says on licensing, but my biggest one, my number one and number two, when you sleep.
Turn the page, Greg.
Got it. Is it there?
Yep.
When you sleep with dogs, you get fleas. Basically, what I'm saying is the licensor, make sure the licensee has manufactured the type of products of a quality which you want to see your brand on. If they're manufactured schlock products all along, and all of a sudden you're Tiffany and you're trying to license them to use the Tiffany label, they're not going to manufacture the products of the quality you want. The other one is no partnerships in licensing. I attend, Danny and I we've talked at many licensing conferences, and licensors and licensees alike all talk about partnerships. There is no partnership. If you look at a license agreement, take a Disney license agreement, put it into a word processor and look for the word partner. You'll see it once, and it'll say, this is not a partnership. So just understand that. The other thing is every license agreement is negotiable, no matter what they're told. Everyone should be negotiable. Danny, want to go Simon's rules?
Yeah, if you put them up there, I can do them.
Well, this is also how not to negotiate. The objective is not to drive a stake through your adversary's heart. You're going to be dealing with these people down the road, and license executives have memories like elephants. Give them a hard time.
You're not
now.
showing your image, Gregory.
Right, you're going to have trouble the next time. Danny.
There you go. You got your knife through the heart. Now go to mine. I won't talk about we're not talking, this isn't a sales conference, so selling, this really applies to selling. Uh, the third point is to me one of the core elements of any deal I do. If you don't make the deal fair, it's not going to work. Somebody isn't going to be happy at the end of the day. And what I want to do is I want to find licensees that I can work with on multiple licenses. And so I want to spend the time getting to know your company so I can work with you not for just this license, but for others in the future. Move forward, will you, Greg? Uh, as I said, on sales projections, beware. They're always going to be low. Know that going in, but try to remember that if the deal isn't fair, going back to the last one, you're never going to make it work. Keep going, Wade, Gregory. Uh, the one I want to really say is the last one. A business law teacher gave me this years ago. The strongest memory is weaker than the palest ink. If it isn't written down, good luck proving your point. I always say to everybody, write it down. Uh, I don't do deals on handshakes. I do them by paper. And anything I want in an agreement that I want to enforce, I want it written down. That's my rules.
And then we come to some books Danny and I have done together. They're good as reference books. You may want to consider them, all of which are on Amazon. There's a couple of additional books with Walters Kluwer and Thomson Reuters, Licensing Royalty Rates, Agreements, and Law of Merchandising Character Licensing. And any questions, if you have any questions, raise them now or drop us an email and we're happy to answer them.
Sure.
And however we can help, we're around.
Okay, so it actually looks like we have a few questions in our Q&A box, actually. I'll try to cipher through all this. Let's see. Are you saying licensors grant tariff relief? If so, what does that relief look like?
Say that again.
Are you seeing licensors grant tariff relief? If so, what does that relief look like?
Well, the tariff relief would be obviously pegged to what the tariff cost is. So the question is, and that is yet to come up, at least I haven't negotiated one that has it in it, but I'm sure it's going to become a factor if these tariffs continue. It's like a tax, and taxes have always been generally deductible. So the question is, will we consider the tariff to be a tax and therefore deductible? So it's yet to be tested, I think, in the marketplace. But I've got to tell you that the toy industry is clamoring for that point of view, that tariffs should be something that is a deductible allowance.
It'll fall under the definition of net sales as deductible allowances. So, and again, if you're a licensor, that's what you're going to be focusing on. The licensee is going to want to be able to deduct it. The licensor is not going to let them deduct it. So you got the push and pull of licensor versus licensee, but it is going to be an issue going forward. Certainly.
Oh, yeah.
Okay, there's another one. What do you think about royalty waterfall provisions for sales?
I'm not sure I understand what they meant by waterfall.
Yeah, I'm not sure either
I'm not sure
myself.
I do either.
Okay, let's see.
If it's a fountain, that's agreeable.
Explain the consequences of a quote unquote naked license or a license without approvals of quality of the merch, please. Immediate loss of trademark rights, possible erosion of trademark rights.
It's called naked licensing, and what it is the licensing of your trademark without enforcing the quality control provisions, enforcing quality control at all. So I grant you a license to use my my trademark, but I'm not inspecting property. I'm not giving you. I'm not asking for samples. I'm not approving samples. trademarks is, and there are a slew of cases. Dunkin' Donuts happens to be one of the cases, which talks about it. But there's a slew of cases. That's one of the major potential liabilities for a licensor, and that's the reason you'll see extensive quality control provisions in any trademark or merchandising license agreement, because the licensor doesn't want to run the risk of losing their license, their underlying trademark.
All right, perfect. Thank you. And let's see, we have a few more. If the licensor agrees not to grant to third parties, isn't it effectively an exclusive license? Wouldn't a court interpret it as such?
Well, it depends. It depends how the license is written. With Greg's clause, there's an escape from there's a provision that allows him to consider it exclusive.
Could you read that question one more time? I'm not sure I fully understand it.
Yes. If a licensor agrees not to grant to third parties, isn't it effectively an exclusive license? So wouldn't a court interpret it as such?
I think it could be argued that certainly it's kind of a backdoor exclusive license. Well, what is but usually there's a provision before it which talks about identifying it's either exclusive or non-exclusive. I'm assuming the question means if the agreement states non-exclusive, but they agree not to, does that make a non-exclusive license an exclusive license? I think an argument can be made it does.
But whether it would hold up in a bankruptcy court is a whole nother factor.
You know, the other thing, which is a little bit of a twist when you talk about license grants, and this agreement doesn't provide for it, but does an exclusive license mean to the exclusion of the licensor or just to the exclusion of third parties? And that's something which has to be identified in the provision.
Yeah, generally we maintain the right to be able to sell product irrespective of your right, whether it's exclusive or not.
Right.
And primarily because we want to be in the business of maybe making a premium to promote our property, or now with print on demand, may want to actually be in the business and want to have that right to do that. Disney, for example, maintains a right to be able to sell product in their store no matter what license you have. So they can make their own product to sell in the stores, in their stores.
Danny alluded to a carve-out. There's typically always a carve-out for premiums and promotions. The reason for the carve-out is the royalty structure, the compensation structure of those deals are radically different than a typical merchandise and license agreement. So the licensor typically retains those rights and will normally, even if I've got a toy licensee manufacturing toy action figures, but I retain the rights to enter into a premium deal for action figures with a premium manufacturer, which could be a different person. That doesn't violate the original merchandising agreement.
It was born out of the fact that the studios didn't want to ever be in a position where they couldn't market against their movie a premium that would promote the film. I mean, that's really where it stemmed from.
Well, the royalty rate structure is different too, with a merchandising license.
But it is structured irrespective of the structure. The whole thing is I couldn't stop a studio from creating a Burger King tie-in for their movie because I have a license with a company for a toy that would conflict.
Right.
Alrighty, well, that looks like we're at time. Thank you so much for your time, Greg and Dan, and thank you so much to our audience for joining us today. Have a good afternoon, everybody.
Thank you, you too.
Thank you.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.